Justice Jackson?
So when I'm thinking about this, I am mindful of the narrowness of the question presented as you have set it forth. You say whether the only permissible exceptions to a general appeal waiver are for claims of an ineffective assistance of counsel or that the sentence exceeds the statutory maximum.
Correct.
I suppose we could answer no.
Yes.
To the extent that we see other exceptions that some of the other circuits have accepted, and we think those should be allowed as well. This questioning that you're getting is, I think, an effort to say what we could offer more than that.
Yeah.
What exactly are circuits supposed to be doing, and you point to contract principles, but I guess that doesn't necessarily have to be where we go with this, right?
Correct. I mean, the question presented is if the circuit is obviously wrong, please reverse and let us try to get a defense. But because there was questioning about, well, what will that mean on remand? But no, you just need to say the Fifth Circuit's rule is indefensible.
Yes, and I guess let me just add one thing or ask one thing about the conversation with Justice Kavanaugh. I guess I'm not sure that Congress or the Rules Committee would necessarily be the only body that could determine whether these kinds of waivers are categorically unenforceable. I would think that based on our case law and sort of standing principles about knowing and voluntary waivers, that this court could perhaps avoid the concerns about picking a particular set of waivers, exceptions, which ones, are they contract principles or whatever, if we could be, enough of us, persuaded that in a circumstance where the defendant is pleading guilty and we know a sentencing hearing will happen, it is not sufficiently knowing to have a waiver of any errors that are going to happen in that sentencing proceeding, that it's just not an enforceable thing consistent with our understanding of knowingness and voluntariness with respect to the exercise of one's ability to make a waiver.
So, A, correct, and B, that's the law that Congress passed in 1984, was that you could bring appeals. Appeal waivers didn't even become boilerplate until the late 2000s. So we had a world in which you could just appeal your sentence. There was no flood.
And it's hard to see,
but
really.
I'm not going to get any votes for this. So.
I know, I understand. You don't want to waste your time because
no,
you feel that
I love
it
what
is
you're
not.
Saying, and nothing bad would happen, too.
You feel it's not productive, but my job is to make sure that all of the issues are being taken into account when the court decides what they're going to do.
Oh, I think
and
you can get there.
My point is that when we're thinking about what a waiver is and we're trying to understand the circumstances and we're balancing the public policy issues on both sides, I'm going to ask the government, what are they gaining out of ensuring that people don't appeal obvious errors in their sentencing? Like, what's the public policy interest in that? So all of those things might lead one rationally to think it's really not worth the candle for us to try to parse out exactly what kinds of waivers in which situations we would allow or not allow, as opposed to just saying we're not going to allow this sort of thing because of the knowingness and voluntariness problem.
I mean, as I sit here, I kind of like what you're saying, and I actually think it's a way of looking at it because nobody brings these appeals. I think from the government, just putting the government hat on, they just don't like the guideline appeals because people get, their advisory, and if the court goes above it. But you could get all the same way and say, well, that has to be knowing because everyone knows that the guidelines are advisory. Just in terms of the state of the law now, it's just not that bad for the government. They just don't. Okay. Thank you.
Thank you, counsel.